because the law has no place in the bedroom or private lives of individuals. That is the crux of the matter.
In a major win for LGBTQ+ rights, the High Court of Saint Lucia has ruled that Sections 132 and 133 of the Criminal Code, criminalizing buggery and gross indecency, are unconstitutional. The landmark decision, secured by the Eastern Caribbean Alliance for Diversity and Equality, ECADE, marks a pivotal moment in the region's human rights landscape.
The Buggery law still exists. All it does is indicate that if two persons in private, 16 years and above, knowing that Saint Lucia law says age of consent is 16, it is now in conformity with other laws that already exist. But if you are going to engage a minor who is below that age, please note that it is still a criminal matter. And we want to be clear about this because this is not opening a floodgate like people believe. You know, as an organization who believe in human rights, we want to make sure we get it right and we put the right information out there.
While LGBTQ+ advocates are celebrating a historic High Court ruling striking down laws criminalizing same-sex intimacy, they remain mindful of the road ahead. Attorney-at-law Veronica Snack emphasized that despite the legal victory, local lawmakers must now act to formally amend Saint Lucia's constitution to reflect the court's decision.
Court cannot dictate to Parliament in any sense, and it is something that we would have to actively pursue to ensure that that does happen. I think the government of St. Lucia has, although it is a hard-fought case, the government of St. Lucia fought. We had other decisions where there was not that level of opposition, but they fought at every single point. We had multiple case management reviews. We had multiple issues that came up then. And we basically fought this case all the way to the trial. They did not give up. But it is up to the government. Obviously, the court, once the court rules, the decision of the court on this issue in terms of the Bill of Rights in a constitutional matter, the decision takes effect. But actually activating that provision by making the amendment within the act itself and passing in Parliament is for Parliament to do, and that is another step that that we have to take.
While the government now has 42 days to appeal the ruling, LGBTQ+ advocates remain focused on long-term reform. The case was fought on a pro bono basis by a team of dedicated legal professionals who underscored the importance of the challenge in advancing equality and justice for LGBTQ+ St. Lucians.
In order to protect persons who may be in a situation where they are, where it is enforced sexual intercourse, they would have, if the law itself was removed in its entirety, then they would have no protection. And that is not what the aim of this case was, or of the LGBTQ community. The issue is really, if LGBT persons are treated as unapprehended criminals simply because they hold hands in public, or they might do something else, in public or in private, or they have relations with somebody in private where both persons are of the age and consent, what is the law's business in that situation?
The Eastern Caribbean Supreme Court found the laws violated key constitutional rights enshrined in Saint Lucia's Constitution, including privacy, liberty, and protection from discrimination. This historic judgment adds momentum to growing regional efforts to dismantle colonial-era laws targeting LGBTQ+ individuals. Solange Alfred, HTS News Force.